All right, the item for consideration now is H.R. 6707, offered by Representative Golden. I ask unanimous consent that the Subcommittee for Indigenous Peoples of the United States be discharged from further consideration of the bill. Without objection, the bill will be considered as read and open for amendment at any point. I now recognize myself to speak on the legislation. H.R. 6707 was introduced by Representative Golden. It advances equity for the Wabanaki tribes in Maine by ensuring that all future federal Indian laws apply to the state. Enacted in 1980, the Maine Indian Claims Settlement Act, or MICSA, extinguished the legal claims of the Wabanaki tribes to their historic lands in Maine in exchange for funds to allow the tribes to purchase lands, provide general revenue, and establish old age pensions for their members. In addition, MICSA ratified the state-level Maine Implementing Act, which extended state civil and criminal justice and criminal jurisdiction over each of the tribes. Notably, MICSA blocked any federal law previously enacted for the benefit of tribes from applying to Maine if that law would affect state jurisdiction, with some limited exceptions. MICSA similarly restrained the application of future federal Indian laws in Maine unless the law specified that it would apply to Maine. And this exclusion is unique to the Wabanaki tribes. No other federally recognized tribes are subject to such a sweeping exclusion from federal Indian laws. In addition to other critical laws, MICSA has prevented the application of the Violence Against Women Act, the Indian Health Care Improvement Act, and the Stafford Act from applying to the Wabanaki tribes. H.R. 6707 represents years of negotiation between the Wabanaki tribes and the state of Maine and is viewed as a hard-fought first step toward complete equity with other federally recognized tribes. The legislation will allow the Wabanaki tribes to benefit from future enacted federal Indian laws. We'll also apply the Indian Child Welfare Act to the Holton Band of Maliseet Indians and the Micmac Nation in the same way that the law applies to the Penobscot Nation and the Passamaquoddy tribe under MICSA. Hope I pronounced everything right and all that. I urge my colleagues to vote yes on H.R. 6707 and yield back. Before we consider amendments, does any other member wish to be recognized on this bill?
Mr. Chairman.
The gentleman's recognized.
Thank you, Mr. Chairman. H.R. 6707 would extend the applicability of future federal Indian laws to the Wabanaki tribes and extend the Indian Child Welfare Act to the Holton Band of Maliseet Indians. Currently, the 4 federally recognized tribes in the state of Maine, known as the Wabanaki, are excluded from federal Indian law. Congress enacted the Maine Indian Claims Settlement Act to extinguish legal claims for tribes in Maine and to exchange their historic lands for trust funds that would allow them to generate revenue. Importantly, the Act prohibits federal laws for the benefit of tribes from applying to the state of Maine if the law would affect state jurisdiction. While the intent of this bill may be to extend future federal Indian laws to tribes in Maine, it could result in a mess for the state government and duplicative regulations and increased compliance costs that result in higher prices for Mainers during a time of already record inflation. For example, the state of Maine has exercised jurisdiction over civil and criminal matters for the last 40 years, including certain federal delegations of authority, such as implementing the Clean Air Act and Clean Water Act. This act would allow tribes to obtain treatment as state authority under the Clean Water Act and lead to the displacement of or conflict with already existing state standards. Unless the provisions of this bill were closely coordinated with the state of Maine, H.R. 6707 could lead to a storm of conflict between tribal, state, and federal laws and governance. The bottom line is the state of Maine does not support this bill as it is currently written, and I cannot either. I oppose this bill and yield back.
Does any other member wish to be recognized on the bill? All right. Is there further debate before we begin the amendment process? Without objection, hang on a sec. All right, without objection, the ANS offered by Mr. Grijalva is considered as read and open to amendment at any point. Representative Obernolte, I understand that you have an amendment designated number 1. You're recognized for 5 minutes.
Thank you, Mr. Chairman. The Subcommittee on Indigenous Peoples had a robust discussion of this bill when it was heard several weeks ago. This bill amends the Maine Indian Claims Settlement Act, which was a agreement with multiple parties between the state of Maine, the affected tribes, and the federal government. So all three of these parties agreed to what is an incredibly complicated piece of legislation. If anyone has not waded through it, I challenge you to go and read it and try to understand what it says. It is very complex. This bill is seeking to amend that settlement act with, I think, a good intention, which is to give the tribes in Maine some of the federal benefits that they currently lack. Unfortunately, the bill is being legislated without the concurrence of the state of Maine. So what came out in the hearing is the fact that in many ways the state has not weighed in on the way that this will affect their relationships with the tribes. So I believe very strongly that the intention of behind this bill is good, but that we should not be wading in and dictating to the state of Maine what their agreement with the tribes should be. So we've gotten some recent indications that the state is engaging on this issue, and I'm in hopes that perhaps we can get to a place where all three of these parties can reach an agreement. So this amendment, amendment number 1, makes a very simple change to the bill. It requires a finding by the Department of Interior that some of the concerns that the state of Maine have raised with respect to the bill will not come to fruition, namely that it will not raise energy costs for the people of Maine. The state is concerned that under some federal statutes, such as the Clean Air Act and the Clean Water Act, this would impose substantially higher energy costs on the people of Maine. And I think in an era when we're experiencing the highest gas prices in history and record inflation, that's something we can all sympathize with. So it's a very simple amendment, and I urge its adoption. I yield back.
I thank the gentleman. Is there any further comment on the amendment? Ms. McCollum, you're recognized for 5 minutes.
Well, we hear from the Maine delegation quite often about the amount of pollution that's coming in from into the state and how it's affecting health and air quality. And I won't get into that discussion with you right now. I'm just going to take down a subsection of why I think that this is so important. When Congress passed the Violence Against Women Act, Maine had all kinds of objections about letting jurisdiction and prosecution and a whole lot of things against the Violence Against Women Act, and they were using their language with what they had settled with the tribes on it. And I disagree with that, but you know, that's one discussion. But the thing that really was aggravating that the state of Maine did was we put funding in there to help women who had been victims of sexual violence. And Maine refused, flat out refused to, with that set aside and with what we were doing to help women, tribal women who had been victims of crime. Maine said, nope, we're not giving you any of that money. We're not spending any of that money. The federal government had no business. This was money going directly to help women heal who had been victims of sexual assault. And for that, Maine has, the way that Maine has treated everything that we've tried to do to even help individual, when money has been targeted towards the individual, I'm going to be opposing both amendments that are going to be offered, because that goes beyond the pale. We all voted as members of Congress that women who had been victims of sexual violence, tribal women, were going to get the help that they needed. And the state of Maine said, nope, that's not allowed. And so just for that pure reason, and I think you can hear my passion on this, I'm going to be opposing your amendments and anything to, take this bill down. I've had enough of bureaucrats in Maine telling us when we're trying to provide healing opportunities for women, nope, you don't get it because this is the way we interpret Maine law when it comes to tribal rights. And I know that's not your intention, but I want you to know my intention, why I'm not going to be voting for anything to dilute this bill.
Does any other member wish to speak on this amendment?
Mr. Chairman.
Yeah, the ranking member is recognized.
Thank you, Mr. Chairman. I support Mr. Overnolte's amendment and understand the argument that the gentlelady is making, but this bill is much broader than any one specific issue and would give broad rights to the tribe. And there appears to be a disconnect between the congressional delegation in Maine and the state of Maine. And the gentleman's amendment simply would require there to be an assessment on whether this was going to raise energy prices on Mainers before this law went into effect. I appreciate Mr. Overnolte's amendment and taking the time to look at what effects this bill would cost before it went into effect. I urge you all to support this amendment, and I yield back.
All right, I recognize myself next, and I just want to point out that this bill has nothing to do with energy policy. It would allow future federal Indian laws to apply to the federally recognized tribes in Maine. The application of existing federal laws would remain unchanged. No other federally recognized tribes are restricted from federal Indian laws in the way that the Wabanaki tribes are. That's what this bill is all about. It's an issue of equity. As members of Congress, we owe the Wabanaki tribes a serious focused discussion on this legislation. Nothing in this amendment would reduce current energy costs to consumers. So this amendment is not a solution to the high energy costs that we're all concerned about. It would only delay the implementation of long-awaited legislation for reasons totally unrelated to the matter at hand. So I urge my colleagues to vote no on the amendment, and I yield back. Is there any further discussion on this amendment?
Mr. Chair.
Yes.
Mr. Chair.
The gentlelady from New Mexico is recognized.
I also must oppose this amendment. And I think in this instance, for those of us who have worked in Indian country for many, many years, we know that one of the issues has always been that states and tribes don't always agree. And that's why it's important to recognize when a federally recognized tribe is federally recognized, it means that they have certain rights that come along with that recognition. For historic, these tribes in Maine do not have it. The Wabanaki tribe does not have it. And this is another one of those instances where we are trying to fix something and make it equitable, that if you are a federally recognized tribe, you are going to have the benefits that all other federally recognized tribes have. And the nice thing is we'll notice that this is only on a going forward basis. They are not trying to unravel everything that happened until this bill passes. It is simply on a going forward basis. It is unfortunate. Some places, tribes and states have learned how to get together and work together for their joint interests. New Mexico is one of those places, but many other locations, states resist the fact that tribes are not, federally recognized tribes are not under states. They are both sort of at the same level working with the federal government. And so that's all this bill is doing. And I support the bill in its present form. Thank you, Mr. Chair. And I yield back.
Thank you. Are there any other members that wish to speak? Yes, gentleman from Idaho.
Thank you, Mr. Chairman. Yield my time to Mr. Obernolte.
Mr. Olbanolt, you're recognized.
I thank the gentleman for yielding. I just would like us to think about what we're doing here for a moment. So we in the United States believe in a system of federalism. We've given our states jurisdiction over some matters, and our federal constitution allows the federal government to claim preeminence in a narrow domain, which does not include interfering with the legal agreements that the states have entered into. So what we're talking about doing with this bill, and again, a well-intentioned bill, is to essentially nullify part of an agreement that was negotiated and signed by all the parties decades ago. And to say retroactively, we don't agree with this, and so we're going to force the state of Maine back to the negotiating table on this. So I fear not only the consequences of that decision, but I also fear the precedent that might be set here. I mean, are we really saying to any tribe in the country if you have a dispute with your state. Come to Congress and ask us to nullify agreements that you've entered into. I just think that sets a very dangerous precedent. And I don't think the things that we're asking of the tribe in the state of Maine here are unreasonable. So I'll yield back.
Hearing no further debate, the question is on the Obernolte Amendment number 1 to the bill. I'll pause so that members joining remotely can unmute. All those in favor say aye.
Aye.
All those opposed say no. In the opinion of the chair, the noes have it, and the amendment is not agreed to. Representative Obernolte, I understand you have another amendment, designated number 2. You are recognized for 5 minutes.
Well, thank you, Mr. Chairman. Amendment number 2, in furtherance of our discussion about this bill, merely would require that before the bill is enacted, that the state of Maine, the tribes, and the federal government enter into a memorandum of understanding concerning the application of some federal laws to the state and the tribes, namely the Clean Air Act and the Clean Water Act, which is the concerns that the state has raised that enactment of this bill would affect. So I think it makes sense that all of the parties affected should have to come to the bargaining table and negotiate exactly the ways that these rules are going to be applied before we take this step. And with that, I urge adoption of my amendment.
Does any other member wish to speak on this amendment?
Mr. Chairman.
Yes, ranking member is recognized.
Thank you, Mr. Chairman. As the gentleman noted, this bill would simply, or amendment would simply require an MOU between the state and the tribe on how the day-to-day business and activities of the state would be conducted. Under current law, the state carries out certain functions under the Clean Air and the Clean Water Act, and this bill would totally upend that. So I think it's good governance, and it makes sense that if this bill somehow gets pushed through and signed into law, that at least there's a memorandum of understanding so that we don't turn the actions and the activities of the state government totally upside down. This is a common sense, good governance amendment. I support it, and I urge our colleagues to support it.
I thank the gentleman. I recognize myself for 5 minutes. Let me be very clear. This legislation has no effect, none whatsoever, on the Clean Air Act, the Clean Water Act. These things are already codified into law. If this legislation is passed, it would have no effect on the application of existing federal laws to the state of Maine. This legislation takes a deliberately narrow approach to this very unique situation which we've described, where the Wabanaki tribes are treated very uniquely. It focuses on the application of future federal Indian laws or other laws with tribal provisions. Instead of pursuing an all-encompassing fix that also addresses previously enacted legislation, the Wabanaki tribes united behind this bill, H.R. 6707, to reach common ground with state stakeholders. This amendment would grant the state government the power to delay implementing this bill for as long as it wanted, would put an end to the work that the Wabanaki tribes have done to get us to this point today. So I urge my colleagues to vote no on the amendment and yield back, and I will ask if any other members wish to speak on this amendment. Hearing no further debate, the question is on Obernolte Amendment number 2 to the bill. I'll pause so that members joining remotely can unmute. All those in favor say aye.
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 All those opposed say no. No.
No.
In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Mr. Chairman,
Yes.
on that question, I request the yeas and nays.
All right. A recorded vote has been requested. The vote will be postponed pursuant to the chair's prior announcement. Any other amendments to this bill? We are going to recess until about 12:45. Staff will provide an update on timing. We will take up Big Cats and get to the votes after we come back. The committee is in recess now, subject to the call of the chair.